together?
Yes, sir.
All right, good. I was talking about the type of mistakes in contract. Like I mentioned, common mistakes, mutual mistakes, unilateral mistakes. Like I said, common mistakes occur when both parties made mistake unknown to the other party at the point of negotiation. The document had been destroyed. I gave the example of a fire incident. We're discussing that, look, I'm selling this property. We have signed. We've sealed the contract. You've made payment. On getting to the property, it has been destroyed by fire. What happened? We call it a common mistake. It was not intended by the seller, and the buyer too was not aware at that point. Then we talk about mutual mistake that occur when parties use obscure language in the sense that at the point you were discussing, at the time you were discussing, party came to a wrong conclusion, different conclusions on an issue. Like I made an example of a seller that has two Sienna vehicles. One is 2015, the other one is 2010. What he had in mind was to sell the one of 2010. And the buyer had in mind of buying the one of 2015. At the point of transferring the interest, the buyer got to know that what the seller was selling was 2010, not 2015 on. Then problem are setting. That is a mutual mistake. Mutual mistake. And that was why at the point of consummating your discussion on any agreement, on anything contract, you have to use plain language. Come out clear. Come out clear. Then we have a unilateral mistake. There's one party, so the country or one of the contracting party made a mistake and was aware of that mistake. So these are things we call mistakes in contract. Above all, we are enjoined to always document all our transactions. Use professionals, lawyers. Want to buy a property, retain the service of a lawyer, estate valuer to help you do the search. Then document all the transaction. For instance, you can't make any claim on property saying that my father gave me this when your father was the one that sold this without any written document, without deed. There must be deed. It must be under deed. That is the position of it. It must be under deed. Now, more importantly, the advent of social media with our phone, smartphone, you can record all discussion, you can record all these transactions. At the point where even signing, record yourself. Like my practice, even if you know, even if you are Professor Wole Soyinka, I will still read that agreement with the content of the agreement. I will read it to your hearing. I will translate it. I will explain paragraph by paragraph so that you understand what you are signing, even at the point of execution, so that the parties to the agreement will know what they are signing and they will know what they are contracting upon. And parties will know their liabilities and obligations. You understand the essence of the agreement. So when you pay your lawyer handsomely, you pay the professional you have engaged handsomely, they will do a good job for you. So you are doing any transaction, get professional to help you document the transaction, reduce everything to writing, and they will put the necessary things that will protect the rights and obligation, interest of the parties as a whole. So I thank you for your rapt attention. I pray with the little we have said, at least just an introductory class. We shall continue from here. We'll move to next topic while we're discussing maybe issues that relate to property acquisition and documentation. At that time, we appreciate the need for us to document agreements, particularly on property acquisition and any other thing as the case may be. You understand? Their last one to like guide each and every one of us and forgive us where we might have erred. Assalamu alaikum wa rahmatullahi wa barakatuh.
Walaikum salam.
جزاك الله خيرا. Well, oh, Jazakumullah khairan for those questions. No, I will tell you from the rear. Now, you have an agreement that offends the Islamic principles, particularly the right of Muslims not to hit haram. I should not hit haram. And you are in doing business, you have to follow the principle of Islam. I'm not a scholar in Islamic concepts, but I can assure you, Allah says we should not indulge in usury. Then you've agreed based on history. Now, you have now realized that at the time you agreed, the principle you used was wrong. What do? You go back to negotiating table to set aside that very agreement and renegotiate afresh in line with Islamic business model. You go and negotiate based on Islamic business models. You understand? Musharaka, Mudoraba, Muharaba. You can use all this. And the person, I will enjoy that person to go and meet Islamic scholar to guide him. You understand? Now that it's clear to you that what you contracted based upon will affect your faith. So it's something that has to do with your faith now, interest. Then the best for you is to go back to drawing board, go back to the negotiating table. So you just set aside that agreement and renegotiate and have a new uh, terms that will altern with Islamic principles. Wallahu hala on that. Then when a breach of agreement, if there's a breach of agreement, then you can make claim. You can sue for damages. You can sue for damages. Remedy. You have remedies under the law. And that's more reason why if you are drawing up an agreement, at the time you are drawing up an agreement by a professional, they must have that at the back of our mind. What will be the penalty if you fail to abide by the concept of this agreement? There will be remedies, and you sue for remedies. That's all. Is a civil wrong? But there's one mistake people used to make. I must stand this. You have a civil transaction. They will go and meet a police officer or go to police station and say, "A police, come and help me recover my money." It's not police duty to recover debt. It's not their duty. The duty of police is clear under Section 4 of the Police Act. They are not debt collectors. You don't approach police to recover your debt for you. Approach a lawyer to sue that person. Late Ganifa Emi will say, sue that bastard. You sue him. You go and sue to claim your money. You don't go and approach the police or go and use the EFCC. No. Or use the military. No. You approach a lawyer. So that is just the position. So that's the mistake. If you want to claim for your damages or you want to claim for a breach of contract or anything, or you want to recover your money, go and meet professional. They know how to do it. By the time they serve the man notice on the other party, or they serve the letter of claim on the other party, stating their claims, the terms, and what they are expecting, what they want to collect as damages, the other person will think twice on what to do. You understand? We should know it. Fine. People will say that if I go to court, time is time wasting, it delays. I waste money, and before you know it, they will appeal. They will do this. Leave that. That era has gone. If you meet a lawyer that knows what to do, you know the way to go about the legal processes, you follow it religiously, you get judgment at the end of the day, and you execute your judgment. You execute your judgment. That's just that. I can level execution if I have a judgment against anyone. You have money in bank, I will garnish that person account and get my money. That is it. So that is the right guidance. I think I answered the questions. Yeah. Inshallah.